Number 31, the people of the state of New York versus Hassan Rkein. Counsel?
With this court's permission, I'd like to reserve 2 minutes for rebuttal.
You may.
Thank you. May it please the court, Mandy Jaramillo with the Office of the Appellate Defender for Hassan Rkein. This court has long held that the justification defense should be given the broadest possible scope. And the trial court here erred when it refused to instruct the jury on ordinary force justification, where Mr. Rkein struck back against an unarmed complainant.
Under the circumstances of this case, explain to me how you think a jury could conclude that defendant used a dangerous instrument but not deadly physical force?
Well, Your Honor, the issue here, if I may go back just one step, is that where there is any reasonable view of the evidence that the defendant could be justified in his return use of force, then that question needs to go to the jury.
But haven't we clearly said that you can't use deadly force except in response to deadly force?
Well, here the defendant was charged with a dangerous instrument, and this court has held in several cases, including People versus McManus, that the elements of the crime are not linked to the elements of the defense.
That may be true, but under those circumstances, but I'm trying to get at here, under our long-held statute, as you, I think, agree, is whether there's a reasonable view of the evidence, right, that this force was justified. Here, if the jury finds that defendant used a dangerous instrument, how can they not find that he used deadly physical force?
Well, here, the jury was not given all of the information. They were not given a holistic view of the evidence by not getting the justification defense. And the jury here showed interest in having that defense.
Well, isn't that answer, you get it, you show that it's warranted by giving it? I mean, you have to show facts, some reasonable view of the evidence, I think Judge Stein is asking, that would warrant giving that. And that's a call for the court. And I think an answer that says, well, if you give it, then they have all the information in front of them, kind of gets around the initial question of what view of the evidence here, particularly in light of the fact that the incident's on videotape, would justify, would warrant this defense going to the jury here.
Yes, and I agree with that. And there is a reasonable view of the evidence here that the justification defense was warranted and should have been given to the jury. We have a case where the jury was well equipped to look at all of the evidence here, and they did have the video of the bar fight. They saw that Mr. Rkein was standing at the bar, that he was shoved in the face by Mr. Reyes, who was, by all accounts, a large man who was quite muscular. The jury learned later on through testimony that he was actually a professional personal trainer.
Did the defendant know that? Was there any evidence at trial that the defendant knew about that?
No, there was no evidence that the defendant knew that he was a personal trainer, but there certainly was evidence of his size and of his build. And Mr. Reyes shoved Mr. Rkein in the face with such force that he sort of, moved back against the bar. His hat fell off, and the video shows.
Are you saying that there was a reasonable view of the evidence that he was entitled to an ordinary force charge, or?
Yes, Your Honor.
That's what you're saying. Okay.
Yes.
So, but how do we get to the fact that he used ordinary force, to a reasonable view of the evidence that that's what he used? And don't you, I think Judge Garcia and I are sort of saying the same thing. Don't you have to have that before the court is required to charge that?
Yes, that's true. But I think the issue is that because he was alleged to have used a dangerous instrument, that the court here, the trial court, found that he therefore, there was this sort of per se exception to this court's rule that he should not get the justification charge. But this court has held clearly
I think the point is dancing around what occurred. So it's how you're going to classify and whether or not the judge gets to do it or the jury gets to do it. taking a glass mug and throwing it in a bar fight at someone's head.
Right.
And I think that's what you've got to address, that particular fact.
That's correct, and it's a very fact-intensive inquiry that the jury was equipped to handle. They were equipped to first determine, that Mr. Rkein was not the initial aggressor, whether Mr. Rkein reasonably believed he needed to strike back with that glass, and then whether that use of force was proportional. And there was a reasonable view of the evidence because of the complainant's size, the fact that this was sort of a surprise attack, and they're also on the video, because it's timed and it's very clear, you can see that from the time that Mr. Rkein sort of steadies himself and gets back up against the bar where he's sort of stable, there are exactly 2 seconds before he grabs a pint glass and throws it on Mr. Riaz.
I wonder why he's under any threat of anything at that moment, Mr. Rkein, because what I think the video shows, and correct me if you think I'm wrong or if there's testimony that says something different or the video is incorrect, that a woman who's about 5 feet tall steps in between them, spreads her hands like this to separate the two of them. And Mr. Riaz, the initial aggressor, as you call him, had his hands at his side, was not doing anything threatening, was simply standing there. What was the threat that Mr. Rkein was at that required him to use any force?
Well, the jury, in viewing the video, could see that there was no sound in the video, but they could see that Mr. Riaz did have his hands somewhat down by his side, but he was tense. His mouth was moving. He was staring. That stare never sort of ended between him and Mr. Rkein. This was an ongoing sort of issue that had not just relaxed or subsided in the way that the testimony came out. So in watching the video, it's clear that Mr. Riaz began something, and that hadn't just ended as soon as the woman stood up. And her testimony actually is that she stood up because she was afraid, in part, that her friend would get in trouble, and I think was trying to keep him
But
from
part of the
going
point
further.
is she's not afraid to get between them.
Well, and that was a choice that she made, but in looking at the video, it's clear that Mr. Riaz has not relaxed, so to speak. I mean, he's tense, he seems to be yelling, and there's...
Can I ask, it seems like you have two arguments. The first is the legal argument, which is, was there a conflation between a dangerous instrument and deadly physical force? And secondly, if there was deadly physical force, was it deadly physical force as a matter of law, or was it a question of fact? Would you agree with that?
I do, Your Honor.
Okay. So let's leave the conflation question aside for a second. I guess it seems to me like you're asking us to re-weigh the facts that the court weighed in deciding this is a matter of law. Is that right?
Well, let me make sure I understand your question, but the court here did not actually look to see if there was a reasonable view of the evidence and then pass that question on to the jury. What the court did instead is rely on this sort of categorical language stating, under New York law, the defendant is not entitled to a justification charge where the uncontroverted evidence is that he used a dangerous instrument, and then named that, saying the pint glass in this case, and therefore can't get the justification charge.
But regardless of whether that was correct, and there is in fact some per se rule, here, as you say, it's fact intensive, it's case by case, and I keep trying to get you back to this case, all right? And the charge is assault with a deadly weapon, okay? So if the jury finds that that wasn't an assault with a deadly weapon, then that's it, it's over, okay? And if the jury finds that there was assault with a deadly weapon, then we know, I think, under the circumstances of this case, that it must have been deadly physical force. Maybe not every case that's going to happen because of differences between the definitions, but in this case, can you tell me how, if the jury found that he used a deadly weapon, that it was not deadly physical force?
Well, if the jury had been, and I see that my time is up, I'd like to continue. If the jury had been given the justification defense, the jury would have then been able to determine, and they may not have necessarily first determined whether or not the glass was a dangerous instrument. The jury may have looked at the situation, the circumstances that we've discussed here in the facts in this case, and determined that Mr. Rkein was justified in his return use use of force. It's the use of force that's either ordinary or deadly, which should not be attached to the object itself. If the jury had determined that he was justified, that would be the end of the inquiry. There is no crime, and there's no point in...
Your legal argument, for you to be successful here, you have to say that that the glass wasn't a dangerous instrument, that deadly physical force is a question of fact for the jury, therefore it's reversible error for failure to charge, and he gets a new trial. That's the goal here, right? And that requires that we look at the facts and reweigh them. And that's the difficulty I'm having in the weighing of the facts, because the use of the glass in and of itself, glass isn't always a dangerous instrument, but there's a fair amount of case law that the use of a bottle in various circumstances constitutes a dangerous instrument. And if it's not being used in reaction to someone else using it, then it moves into the category of the type of force you're using, and as a matter of law, it seems you're stuck with deadly physical force. And even though the court might have misstated what New York law is, in terms of, it doesn't mean he was wrong in this case.
Well, Your Honor, there are cases in the Third and Fourth Department that actually hold the other way, because there was...
I think you're right about that.
With
There's
People
no question,
versus
you're right about
Powell,
that.
there was a glass used, People versus Griffith, and People versus, I believe it was
Counsel, did the
Jones.
defendant request a down charge to assault second on the injury to the head, arguing that the glass was not a dangerous instrument?
No, the defendant requested just the ordinary force justification charge. There was...
No request for a down charge
No.
from the assault second to the assault three, arguing or attempting to argue that the glass was not a dangerous instrument?
No, he did not.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon, Your Honors. My name is Jared Wolkowitz, and I represent the people of the state of New York in this appeal. We would ask that this court affirm the trial court and the appellate division's ruling, which stated under the facts of this particular case, there was no reasonable view of the evidence that the defendant warranted a justification charge. And that is correct if you look at the record here. First, the defendant, there was no reasonable view of the evidence that the defendant used any other force besides deadly physical force. He took a bottle. A glass.
Is a pint glass deadly physical force as a matter of law?
I don't think we need to reach that issue in this particular case, because the jury, one of the things that we talked about, the jury reached that issue. The jury found that it was deadly physical force when the jury received the definition and made a finding that under the circumstances in which it was used, it was readily capable of causing serious physical injury or death. The jury made that finding. So whether it's a matter of law or not is almost irrelevant in the sense that in this particular case, the jury made that finding. Secondly, what I would say is there is no reasonable view of the evidence that when defendant used this dangerous instrument and was confronted with any force whatsoever, it was deadly physical force that he was confronted with. And the legislature has carefully laid out in a justification scheme in which you could only respond to you could only use deadly physical force if you are about to be threatened or facing deadly physical force. This defendant obviously was not. As Judge Wilson was talking about, as you were talking about, his hands were at his side. There was somebody separating between them. The defendant was the one who turned around, picked up a pint glass, and then hit him over the head. He was not facing, at that particular moment, really any force, as Judge Wilson was pointing out, or let alone deadly physical force.
To clarify, did he throw it or actually hold it in his hand and hit him on the head with it?
I don't think the record is actually clear, but to me, it really, it's almost beside the point, because when you're a foot away, whether you actually make the contact with the hand or you throw it so hard that it hits, whether it shatters on the ground or whether it shatters on the floor or on his head, it's obviously you're using it with that type of force from that distance. So whether it actually is projectile by throwing or by smashing it over the head seems in this particular circumstance not to be an important point.
And I take it you would not agree that the manner in which it is used encompasses self-defense?
I'm not sure I understand what you mean.
Sure. That is, when we say whether you consider something a dangerous instrument, it takes into account the manner in which it is used.
Correct.
You're thinking of things like the force, that sort of thing, but not, I was using it in self-defense, and that should figure into whether we consider it a dangerous instrument.
Well, a dangerous instrument and deadly physical force, their definitions in this particular case under these circumstances, I think this is what Judge Stein was alluding to, match each other. So in this particular circumstance, the defendant could not get, and that's all the trial court was saying, in this circumstance, the defendant could not get a dangerous a justification for ordinary force because once they made that finding, then a justification charge would run afoul of the state's justification system. And because the justification law itself states you have to use, as I said before, deadly physical force confronting with deadly physical force. And I do want to get to McManus.
Can there ever be can a person be facing deadly physical force and be entitled to use deadly physical force when the other person is unarmed? Is that possible?
Yes,
Okay.
absolutely. Like,
Right.
for instance, I thought of an example. If I was in a room with Mike Tyson or Vladimir Klitschko, the heavyweight champions of the world, and they're the only ones by the door, and they say, I'm going to kill you, and he doesn't know I have a gun, I think I would be entitled to a justification charge in that particular instance, even though he's not armed at that
Is
particular
that a
point.
question for the jury?
Yes, the question in that particular circumstance, well, no, I'm sorry, let me take that back. That question, I think there would be a reasonable view of the evidence, provided, and I'm assuming because he's a well-known figure, that the victim knew who this person was, that would then be something that the legal guardian, the judge, who is our legal guardian, would be able to shepherd in the sense that the jury would get that.
If he'd been wearing a T-shirt saying, you know, I'm a trained personal trainer at Equinox Gym or wherever he is, would that change it?
Maybe
But
does
Judge
spinning.
Stein, no, but Judge Stein's question, though, and I want to go back, is could you get a deadly physical force justification defense? And the answer would be yes, but they didn't ask for one here. And the question is and that's where I think there's this big gap in analysis between the defense and what we're arguing. McManus only stood for the proposition that you don't get a justification defense. That McManus was an intentional murder and a reckless, depraved murder. And what happened in McManus was the judge said, and I'm going to quote McManus because I think the judge said specifically, in order for you to have justification, you must have intent. And then the court said, no, it follows that there is no basis for limiting the application of the defense of justification, meaning the entity itself, Article 35, in any particular mens rea of any particular crime involving the use of force. Indeed, the legislature has clearly not done so. So if there's a reasonable view of the evidence, nobody is saying here that this defendant could not have gotten a deadly physical force justification charge if asked and if the evidence was there. It wasn't.
Well, let me ask you if the inverse is true. If can a dangerous instrument be used without deadly physical force?
Yes, but they would be, in this particular case, the defendant would be acquitted. And that's the analysis in Powell, that and we said in the brief, we think.
No, I'm familiar with Powell.
Right.
Yeah.
In Powell, they say, likewise, the nature of the in our view, whether the defendant employed ordinary force in the use of the cup to defend himself should have been an issue for the jury as well. Of course.
So in a circumstance where you used a dangerous instrument, but it was used with ordinary physical force, then you would get the charge.
You would, I mean, I can't think of every example, and that's why
I grant you it's rare, but it seems there are circumstances, and we have cases that show that.
Right, I mean, I think the point being, and we say this I think the point is it would be very rare. I can't personally think of one.
But to answer my question, you would get the charge then.
If I can't think of a circumstance, but if you can think of a circumstance, or that's why we're not advocating a per se rule, we're not saying make this a per se rule. We're not saying don't ever get this charge. We're just saying that the judge is allowed to recognize this definitional overlap and not make the jury do this inquiry twice by charging ordinary force.
I see.
And that is essentially our argument. And we think that the case law, McManus, justifies that. And the only thing I would also say, just to finish up on the McManus point, was this court specifically held in McManus that indeed, when I was finishing the mens rea of any particular crime involving use of force, indeed, the legislature has clearly not done so, restrict the defense, meaning because of intent in terms of reckless or intentional, you get a justification defense. But here, the legislature has limited the scope because ordinary force cannot be used to confront, you cannot use deadly physical force to confront ordinary physical force.
Can I just go back?
Sure.
I may have misunderstood something you said. I thought I heard you say in response to Judge Fahey that a jury could find that there's use of a dangerous instrument, but that it's not deadly physical force.
If I said
don't
that,
think you
then
meant
no.
that, right? I didn't think you meant that.
I did not say that. I didn't think I said that.
I may have misunderstood
Right.
you.
What I was trying to say was to Judge Fahey.
And they could
was-
attempt to use a deadly
Right, and I can't think of
instrument.
I'm not
right?
smart
It's
enough to
about
think
that
of
force.
every example in the world where that it could be possible.
No, my point is that the overlap is at the use, not at the attempted to use, right?
The overlap is
Or
definitely at the
threatened
use,
to
yes.
use because deadly force is the actual use.
Absolutely,
So what
yes.
we focus on is on the use.
In this particular case, yes. The overlap is absolutely there. And my point to Judge Fahey, if I can continue because my time is running, was that if they didn't find the use in this particular case, he would have been acquitted.
Thank you,
that was my
counsel.
point. Thank you very much.
Counsel?
Now, why are the people wrong about that? That the overlap here is on the use?
Well, Your Honor, the prosecution is arguing that they're not arguing for a per se rule, and then also stating that they can't come up with an example of when you could get the ordinary force justification charge, but they don't need to come up with an example. There are many examples in the case law, including in People versus Powell, which cites directly to McManus.
Okay, but I'm saying here. I'm sort of in Judge Stein's camp on that. Tell me here how you do that.
Well, here, there are other cases showing that the use of a glass under very fact-intensive situation could be ordinary physical force in return. Here, the jury could see the photos of Mr. Riaz's injuries, which was a minor abrasion to the head. The photos are in the record as well. They could see the video where this is clearly a very quick-paced bar fight, and they could have determined that Mr. Rkein's return use of force by picking something up off of the bar was justified in this case, and that it was justified as ordinary physical force.
It seems to me you're saying one of two things, or maybe both of them, I'm not sure, and maybe there's something that I'm not thinking of. But one possibility is, had the court charged, given the justification charge you wanted, the jury's result on the crime might have been different. You may be saying that, and if so, I want to know why you think that. Or the other you might be saying is, that doesn't actually matter because the law requires giving of the justification charge an independent consideration of the two, even if there is an overlap, maybe even an identical overlap between the two. I'm not sure if you're saying one or both of those.
Yes, I'm certainly saying the latter, Your Honor, based on this court's precedent in McManus, that because there's this dangerous instrument element in the crime, that does not mean that they should not also get the ordinary force justification charge here, where there is a reasonable view of the evidence that he was justified in his return force. The way that the jury could have come to a different determination, and that this idea that because they convicted him on a dangerous instrument element is somehow like a fail-safe is not correct, because we give juries all of the information and they may not interpret it in the...
So are you suggesting that any time that there's a conflict in which someone uses some force in response to some other force, in every case, the jury is entitled to a justification instruction?
No, Your Honor, and there's certainly,
Where would you draw the line without,
Sure. I mean, I think a good example would be looking at the First Department's case in People versus Garcia. In that case, there was an unarmed initial aggressor, and the defendant came back with the claw side of a hammer. In a case like that, and there were significant injuries in that case. In a case like that, you're getting closer to
Are
something.
you saying that the injuries are, so the effect of the use of it is what happens? Because it seems to me that, let's take something that we all agree is a dangerous weapon, and that's a gun.
Sure.
Okay, and you shoot a gun, and it grazes, it just goes right, and there's no serious injuries, but nobody would question the fact that that was the use of a dangerous instrument, right?
That's right, and that's statutorily, that's a deadly weapon as a matter of law.
Right,
but if we're looking at a dangerous instrument, so more in this gray area, I think it is
What
the
I'm
nature.
getting at, it's not the injuries that result, it's how it's used.
Correct.
Right? Okay, I just wanted to clear that up.
Thank you, counsel.
Thank you.